Good day to you and welcome to another Paddocks Club video tutorial. In terms of the Sectional Titles Act, the functions and powers of the body corporate are performed and exercised by the trustees holding office in terms of the rules. Many people are surprised at just how much power the trustees actually have and what decisions can be made on behalf of the body corporate by the trustees without consulting other owners. So it becomes quite an issue if you think the trustees are acting improperly or if you think they just don't care enough. If this is your situation, then there are a number of things you can do. Option number one is to force members off the Board of Trustees. Now, an ordinary resolution and prior notice is required. If there are particular trustees whose behaviour is often unacceptable to owners, they can be removed by a simple majority resolution at a general meeting, provided that the intention to vote on the removal from office has been specified in the notice of the meeting. This is in accordance with Prescribed Management Rule 13E, which gives as one of the grounds for removal, for dismissal from a trustee office, such a removal. You can't just bring this item of business up without notice. This doesn't mean you have to justify the lack of confidence that is clearly held in the person who you think must be removed, but it does mean that the trustees who you are trying to remove must be given an opportunity to know of and to talk against the resolution, and that inevitably will mean that the reasons will be put on the table. Just to clarify a common misconception, there is no basis on which you can take a vote of no confidence in the trustees. The only way to remove them is in terms of Prescribed Management Rule 13E, and you can do that for one of them or all of them. Clearly, if you're removing one or all, you should put on the same agenda the election of new trustees to take their place. The second option is placing restrictions on trustees or giving them specific directions. In terms of Section 39(1) of the Act, the owners in general meeting are by ordinary resolution entitled to give the trustees specific directions or to impose restrictions on them. And if this happens, the trustees are legally obliged to respect those restrictions or to carry out those directions. If they don't want to, they must resign. In regard to both options, 1 and 2, it is possible that the trustees may not wish to call a special general meeting, required either to take a resolution to remove one of their number or to give them specific directions or place restrictions on them. In these circumstances, Prescribed Management Rule 53 applies, and the owners, who are entitled to 25% of the total of the participation quotas of all sections in this scheme, or a mortgagee, a bondholder that is, who holds bonds over not less than 25% of the number of units in the scheme, can in writing demand that the trustees call a meeting. If they fail to do so within 14 days of that written demand, the owner or the bondholder concerned is entitled to call the meeting themselves. Option 3 is, in essence, making sure that the next set of trustees are better than the current ones. The election of trustees is a mandatory item on the agenda of every annual general meeting of a sectional title body corporate. Once the old trustees have completed their job, given their reports, presented their budgets, and managed the process of the annual general meeting, they vacate their office. In some schemes, the same people get appointed to serve as trustees year after year, and in many schemes, this is a good reason for this. They're the best people for the job. But if you don't like the way the incumbent trustees are running the sectional title scheme and don't want them to be re-elected, then you can do something about it. You need to start work on this well before the annual general meeting and decide whether you personally are prepared to serve. Getting other people to run the scheme the way you think it should be run is very much easier if you are also prepared to shoulder some of the burden personally. Step 1 is to find people who you think are suitable and willing to serve. The second step, and probably the most critical, is to ensure that those people are properly nominated and that written nomination forms are lodged well before the annual general meeting. And your third and also critical thing is that you must lobby, you must talk to other owners, you must play the game of politics and inspire other owners to support your group and to vote for them, which presupposes that they are present or represented at the annual general meeting, and their proxies have specific instructions to vote for those people. So if you're in a scheme where general meetings are seldom well attended, you need to do something about that. You may want to consider drafting a proxy for owners who won't be able to be present personally at the annual general meeting, with wording in the form that specifically instructs them to vote, or the proxy to vote for your team. Thank you for joining me in this Paddocks Club video tutorial. If you have any questions or comments in regard to these topics, please post them in the discussion forum.